Hello everyone, I welcome you back to our channel. This is Legal Mindset at the back, and today we are going in for contract law 1. We are going to look at a very keen topic, a sacrosanct topic, paramount and very important for appreciating contract law 1. That is the topic of intention to create legal bounds. You can also call it intention to create legal relations. So, by the end of this topic, you should be able to know what kind of agreements do we intend to create legal relations. What kind of agreements does the law presume not to be legally binding? Hang on until the end of this video, where I shall take you through a number of cases to explain to you what really intention to create legal bounds amounts to. Subscribe, hit that subscription bar, share with your colleagues, keep the comments coming. Where you feel like you're not understanding, what topic do you like most, don't fear us. Tap that subscription bar such that we move together. Now, what is intention to create legal bounds? This is one of the elements of a valid offer. Remember, in this first semester, we are creating a valid contract. So, if there is to be a valid contract, the parties should intend to create legal bounds. And if the parties are not intending to do the same, there cannot be valid contract. But since our course unit, Contract Law 1, is all about and rotates around contract formation, we shall say that intention to create legal bounds is one of the essential elements of a contract. So, Section 9, Subsection 1 of the Contract Act, Cap 284, defines for us what amounts to a valid contract and what is a contract. And in that definition, you shall hear that there is a phrase of the contract shall intend to create legal bounds if it is to be a valid contract. That section provides that a contract is an agreement made with free consent of parties with capacity to contract for a lawful object and for a lawful consideration, with an intention to create legal bounds. Now, to dive into it, the law has two presumptions. So the first presumption is that agreements of domestic and social nature, their parties do not intend to be legally bound. The second is that agreements of commercial or business agreements, there is a presumption to create legal bounds. So let us look at this topic in a way of agreements which intend to create legal bounds and agreements which do not intend to create legal bounds. That means we are going to look at the domestic or social agreements. After, we shall look at the commercial or business agreements. To begin with, a domestic or a social agreement is an agreement where the law presumes that the parties do not intend to create legal bounds because of that connection between them. Family members, husband and wife, mother and child, close friends, such relationship. Take an example like, I have my sister, we enter into an agreement for her to borrow me 200k, but later I do not pay her. She cannot enforce that agreement because the law presumes that our relationship, our contract does not allow us to create legal bounds. And if you look at the case of Balfa versus Balfa, Mr. and Mrs. Balfa were husband and wife, as we talked. They lived together in Sierra Leone, it is present day Sri Lanka. So, they got a time and they went to live in England, but while in England, the lady, Mrs. Balfa, got sick. and she decided to stay in England to take some medication. Now, Mr. Balfour promised to pay Mrs. Balfour £30 every month as maintenance while she was getting the medical care. So later he failed to pay the money and Mrs. Balfour sued for breach of contract. Lord Atkin held that the agreement between husband and wife do not intend to create legal bounds where they have been living harmoniously in amity. Their contracts are not enforceable under the law. Why? They do not intend to create legal bounds. So, I urge you to be very keen. As any general rule, we have exceptions to the general rule that domestic or social agreements do not intend to create legal bounds. Be very keen of these exceptions. Number one is that where the couples have separated, where the agreement is put in writing and it is signed. Because you remember, in law, every person is bound by their own signature. I urge you to look at the case of Merritt versus Merritt. And in that case, Mr. and Mrs. Merritt were a married couple who decided to separate. Those of you who don't know what separation means, separation is like deciding to stay together for a certain period of to stay apart with your married spouse for a certain period of time. Maybe to sort out yourselves. Maybe your marriage is not good. You say, let us separate. But it is not divorce. It is a provisional period. Now, they were in that period. But before, they had a matrimonial house, which was on mortgage. The house was in the name of the man. Now, during that separation, the man met the wife and agreed with her that you complete the mortgage of the house, and after your completion, I will transfer the house to you. The wife did in accordance, and he did the same. She kept on to pay, but she was so wise because while in the car, she told Mr. Merritt to sign somewhere. Now, after the wife had completed to pay the house, the mortgage of the house, the man now claimed that they did not intend to create legal bounds, and he wanted to rely on the rule in the case of Balfour versus Balfour that husband and wife do not intend to create legal bounds. So, Lord Denning held that where an intention to create legal bounds in a contract law is seen in man and woman who are separated. I explained to you separation, and the agreement is put down in writing. That contract is enforceable. Where the parties are no longer living together, they intend to create legal bounds. I urge you to be very clear on that exception because it is paramount for your understanding of the topic. And if you put such an exception, you are impressing the examiner. You're getting yourself high grades. Let us now look at the business or commercial agreements. And on business or commercial agreements, the presumption in the law is that parties intend to create legal bounds. Take an example like you're working for a certain sugarcane plantation. Now, maybe you're a driver there. After you driving, the manager calls you and tells you your allowance is not going to be paid because it was not part of the salary, and you know we did not intend to create legal bounds. No, in business agreements, there is an intention to be legally bound. I urge you to look at the case of Edwards versus Skyways Limited, a case of 1964. And in that case, an airline promised to pay an ex gratia payment to a pilot leaving their company. They promised to pay him a certain amount of money as a way of giving him a good send-off from their company. Now, they later changed themselves and they said, we are no longer paying because we did not intend to create legal relations. Court held that in commercial agreements, the law presumes intention to create legal bounds and that the company was legally bound to pay. That is the commercial or business agreements. You can look at various cases, the Carril versus Carbolic Smoke Ball, where it was an advertisement. Mrs. Carril used the product, but however, the company Carbolic Smoke Ball stated that for them they did not intend to create legal bounds with anyone. They were just exaggerating their sales, and it was an invitation to treat. The court held that business agreements, where it is an engagement of business, there is an intention to create legal bounds. However, like any general rule, there are exceptions to the general rule that business or commercial agreements, parties intend to create legal bounds. And some of these exceptions are where there are express clauses. If parties express a clause in their contract that we do not intend to create legal bounds, it means that that agreement shall not be enforceable under the law. I urge you to look at the case of Rose and Frank Company versus Crompton. And in that case, the contract was not enforceable because the parties included a clause that this contract shall not be legally bound. You can also look at the clauses of the clause of honor, where parties say that this contract shall only be enforceable with honor. I urge you to look at the case of Jones versus Vermont. It is the case of Jones versus Vermont Pools. So in Jones versus Vermont Pools, the parties put it in writing that this contract is only enforceable with the owner and bound by owner. It means you cannot enforce such an agreement as long as it is a business and a commercial agreement. Thank you very much for watching Legal Mindset at the Bar. I urge you to subscribe, share, and comment where you feel like you're not satisfied.